Welcome, folks. I think we have more virtually than in the room, and I want to welcome the folks who came to the office this morning. We appreciate it. My name is Stephen Crain. I'm the litigation section head here at Bracewell. I've been a partner for many years. I've been at the firm for 32 years. So I'm going to introduce our panelists, but before that, I want to introduce sort of the team as a whole on international arbitration. So we've had a long history at the firm of doing a lot of litigation, mostly domestically, and a fair amount of international arbitration, but we've never had a dedicated team that is focused solely on international arbitration, and now we do. It started several years ago when we added disputes to our London office, headed by our partner, John Gilbert, who will be speaking with you all. And then last year, we added Martin Gusy, who has practiced in the space for a long time. I'll say a little bit more about them. And then we've married those teams up in London and in New York. Martin's in New York, with our Houston litigators, including Sean Gorman, who has a depth of experience in international arbitration. And you'll hear from all of them today. So I do want to welcome the team and sort of, this is the first, sounds like a bird just hit right behind me. This is the first of several CLEs that we'll be doing here internationally, New York, et cetera, to make sure that the world knows about our first-class team. So you will hear from Martin Gusy, German by birth, New Yorker by choice, I think. He's dual qualified in Germany and New York. He has a long history in international arbitration. And when we decided to take our practice in London and marry it up with our U.S. practice through international arbitration, Martin is who I sought out for that role. John Gilbert, who will appear virtually, I see him on the screen there. He's London-based. He's Cambridge educated. He is 22 years qualified and has been with the firm for several years now. Sean Gorman is a partner here in the Houston office. He's been practicing for 34 years or so. And has multiple chambers rankings and again, a great depth of experience. Manuel Vera, who will be speaking, is Mexican by birth, Texan by choice, I suppose I should say. He's dual qualified in Mexico and the U.S. and is one of our partners who really does a lot of our international transactions. So a lot of cross-border experience. Finally, well, y'all will hear from Steve Andersen, who is a director at the ICDR, overseeing Canada, Mexico, and the U.S. Excuse me. And you'll hear from Manuel Cervantes, who's the managing director of MCM Abogados, which is a premier law firm based in Mexico in energy transactions. So with that, why don't we have our first group come up? And I think that is Martin, who is the bearded one. He can introduce himself, and Sean Gorman, the non-bearded one. And I'll let Martin introduce the rest of the panel. Thank you.
We've got 90 minutes to talk about strategic use of international arbitration and Mexico. That's a mouthful in itself. What we see here in our practices and would like to discuss is the complex scenarios, the disputes where you have got multiple parties and multiple interests. Given our respective practices, these things happen a lot in the energy space. We will also touch upon IP disputes. And last but not least, use Mexico as an example where international arbitration, precisely said investor-state arbitration, can be used for strategic purposes, if any, to actually gain leverage with the sovereign. You have heard about international arbitration as being the cheaper and faster, one-size-fits-all, mighty way of resolving disputes. That has been criticized in plenty of events. But what we did want to point out is that there are examples where we still believe it is the premier way to resolve disputes, but there are other disciplines that can be very helpful. So the pros and cons of combining international arbitration with litigation in the fields of IP, energy, and investment arbitration is the agenda for today. I suggest we get started with a few examples of international arbitration and litigation having been combined. So that's the strategic allocation of different parts of a dispute to different fora. Mediation jumps to mind. US-style discovery is something we should touch upon. And the natural place to start when it comes to discovery and international arbitration, I would think, is 28 USC section 1782, a topic that is to be looked at by the Supreme Court of the United States. Sean?
Sure. So Section 1782 permits litigants to invoke the authority of the United States court system to assist in the gathering of evidence in a foreign tribunal, foreign court, or an international tribunal. The dispute among the federal courts of appeals right now is whether it applies to a purely private foreign commercial arbitration. And that issue now has made its way to the United States Supreme Court. There are two pending cases where the Supreme Court will address this issue of whether it can be used in private commercial arbitrations. And of course, it's very desirable because you get the best of both. On the one hand, you have an arbitral tribunal. On the other, you have U.S.-style discovery with the power of the U.S. federal courts to enforce compliance. A very powerful tool.
Now, I think it's been almost uncontroversial that in investor-state arbitration, there may be a resort to this type of discovery.
Yes.
What's in front of the Supreme Court at this point solely addresses commercial disputes, does it?
Correct. Private foreign commercial disputes where the forum, the resolution forum, is under contract, where the arbitrators are privately paid, where there is not a foreign state involved. And the issue before the Supreme Court is whether the statute's use of foreign or international tribunal means only a foreign government's tribunal.
Indeed, indeed. And would it matter what the tribunal that's actually sitting on such a dispute thinks about whether Section 1782 discovery should be used?
No. This is going to be something that is decided by the U.S. Supreme Court based on the U.S. statute that dates from 1964 that was reflecting issues in American law back 100 or more years. So whether the tribunal or it itself thinks that it is a foreign or international tribunal, I don't think is going to matter in this outcome.
We will see. We have no crystal ball here.
Yes.
That said, I believe we argued a position in the Third Circuit on this issue, didn't we?
Yes. The firm had this issue arise in a proceeding in the Third Circuit. As with so often, I mean, before the current two cases in front of the Supreme Court of the United States, there was another, but it was resolved, so it becomes moot. And our case in front of the Third Circuit also was resolved. It likely would have gone to the Supreme Court as well. These are hotly contested issues. The side that is trying to invoke the power of the United States federal courts have enormous desire to do it. The side that is resisting that also have enormous desire not to let this happen, because U.S.-style discovery is so powerful and can be so invasive that this is a hotly contested issue. So, it is still possible that the two cases in front of the Supreme Court right now, Alix Partners and AF Automotive, will be resolved and settled. But, it keeps popping up.
We'll get back to U.S.-style discovery.
Yes.
But in between, let's remember what brings people to arbitration is an agreement to do so. And if you're a user of this type of dispute resolution, you have a unique opportunity to agree on how to do this. So the drafting of the particular clause is what triggers international arbitration. Now, you can provide for multiple tiers to go through before you get in front of an arbitration tribunal. And I prefaced this part of the program with a scenario of multiple parties in a complex dispute, isn't that a great place to conduct mediation early? What do you think about that, Sean?
I think it is because, of course, first you avoid the expense of a lengthy arbitration. And if one party tries to invoke Section 7082, you avoid the expense of all of that effort. It's also, to have a mediation early. Perhaps if perhaps the parties are more interested in reaching a resolution, you can even file an arbitration and ask the tribunal to stay it while you mediate, so you have the threat of this proceeding hanging over the heads of the parties. You can force everyone to get together, which may not have been possible prior to filing the arbitration. So I think it's always worth thinking about. Now, at the same time, it often it doesn't work. I mean, sometimes if complicated disputes among sophisticated parties have lingered and have not been resolved through normal business channels, that's an indication that they may not be resolvable on a voluntary basis and is going to require the resolution of the tribunal, or at least the beginning of the final hearing before the parties get serious. But it's worth trying mediation early on.
Yeah, I mean, mediation being voluntary, of course, I mean, it takes the will of the parties to do so.
Yes.
And it might help to actually pick a mediator that the likely payer in the dispute resolution scheme agrees to, most often being the defendant. There may be cross-claims, though. This brings me to a related issue. Mediation, is an opportunity to involve people who, or I should say parties, who may not be within the same group of jurisdiction that then can give rise to international arbitration proceedings. Again, voluntariness is the key word here. With that said, arbitration and litigation most often are mutually exclusive unless there are these rare scenarios where things are combined, and I'll get back to that in the context of IP litigation. If a true fraud is the subject matter,
right,
that you as a claimant or future claimant would like to raise. Now, any sentiments in terms of if one or the other way of resolving the dispute, arbitration versus litigation, is perhaps the better route?
Well, certainly with fraud, usually the evidence of fraud is not going to be in your own possession. The evidence of the other side's fraud is not going to be in your possession. In a breach of contract, you may not need information from the other side as much or at all. But in fraud, to establish fraudulent intent, you need to get into the documents and the witnesses of the other side. And so certainly either through Section 1782 discovery or through a parallel American litigation, that can be extremely helpful to force the other side to come clean about what they were thinking, what they were doing. We just went through discovery in a fraud case, and the evidence of fraud was uncovered in the other side's negotiation updates. During the negotiation of an agreement, the other side was circulating among the negotiation team updates that showed fraudulent intent. And so without the ability to obtain that information, we suspected fraud, but we can't get into the minds of the other side. And so this was extremely helpful.
Yeah, I appreciate that, especially the fraudulent intent hurdle. That segues into what I wanted to talk about in the context of IP litigation and combined international arbitration in a traditional IP litigation. When I say IP litigation here, I do not mean royalty disputes, which very often on the international plane do go to international arbitration for the very good reasons, because there are breaches of contract. What I'm after is willful infringement of patents. Now, Judge Albright used to be with Bracewell. He's got a heavy docket. There was a dispute that actually involved a piece of litigation in front of him, parallel litigation out in California, and an ICC arbitration. And I think it's worth mentioning because the ICC arbitration arose out of the underlying NDA that had been entered into by the party invoking its patents and wanting to negotiate a license with the alleged infringer. Now, I've prefaced this with willful infringement. Willful infringement requires you to have knowledge and, of course, a plaintiff/claimant to prove that such other party did have knowledge about your patents.
Right.
And if you enter into negotiations to hopefully come out with a license that is subject to royalties, at some point you will have to exchange information.
Yes.
Now, I thought this was a great example, depending on what interests you're representing, to actually do combine US-style litigation for patent infringement with international arbitration, which will then determine the nature and use of the information exchanged leading up to a potential license. That shouldn't be the only example of an IP case where international arbitration can be used strategically, and this is a handover to our partner John Gilbert in London, who told me he was seeing an IP issue resolved in international arbitration where the IP was actually created subsea. I can't wait to hear what that is all about, John.
Well, thanks, Martin. And I think it is a really interesting example of a case where we had to consider very carefully the, I guess, kind of how the correct forum for the resolution of the dispute. So this was a dispute that related to a subsea compressor, essentially a bit of kit used to assist the production from a subsea gas field. And the dispute that arose was related to a joint venture. And this was two very sort of eminent companies that had worked together to develop this impressive technology. And they put in place a joint venture agreement with each bringing its own particular expertise and protected intellectual property to this joint venture. And after working together very closely for a number of years, the two companies had developed an impressive subsea compressor system into which both had made significant contributions. But like all good things, the relationship eventually came to an end. And the question arose as to which of the parties could use the system that they had developed together, including the intellectual property of each of them. And when we first got involved in the dispute, our immediate reaction was to, I guess, kind of question the correct forum for the resolution of the dispute and to consider issues of arbitrability and whether one could really kind of look at this dispute from the perspective of commercial arbitration. And the joint venture agreement itself was a short document, but it did contain an arbitration agreement in it. And so eventually we concluded that really what was at stake was the contractual rights of the parties, each to use the system that had been developed, and once their relationship came to an end. And it was a LCIA arbitration. It was pursued all the way through to a final hearing and to an award. And I think kind of a couple of the things that struck us as we were considering this case was that really arbitration was a particularly useful forum for the resolution of a dispute like this. This was highly sensitive, commercially sensitive material. You know, it was in neither party's interests for there to be any sort of publicity regarding this, either the dispute or the system that had been developed. And going to arbitration also allowed us to appoint a tribunal that was really specialist in terms of the subject matter of the issues that we were facing. And we were particularly careful to appoint an arbitrator who had a very deep background in technical engineering and IP related disputes. And I think when you look at the award that came out, it was clear how influential that arbitrator was in the writing of the award and how much he sort of inputted into it. So I think, it was a case where, our views changed almost, 180 degrees from where we started, where we thought we would be taking the case, which would have been potentially litigation through a number of different national courts with regards to the patents, through to, well, actually it was very successfully resolved through commercial arbitration.
Well, you've hit on a few perceived to be great advantages of international arbitration. When talking about strategic use, confidentiality still does play a role. There are means to do certain parts of US litigation in private, but the existence is inevitably to be discovered by others.
Right, and it's very, courts are, I think, increasingly hesitant to seal pleadings. There is a movement among the federal courts that, if you want confidentiality, you need to choose arbitration, that courts are open, and, some judges will clear the courtroom for certain issues, but you can't count on that. So if it is something that is of utmost importance that secrecy is maintained or confidentiality is maintained, then arbitration is the better choice.
Yeah, I do want to point out that this is something ideally to be picked up by the parties when drafting their agreement. Not every major institutional set of rules, contrary to common perception, actually does provide for confidentiality and privacy when it comes to the proceedings. Now, confidentiality and privacy, John, when it goes to complex disputes involving different kinds of relationships, what I'm after is production sharing agreements on the one side, joint operating agreements underlying them on the other side, different parties being involved. Where is the room and where are the advantages and where are the cons of using international arbitration for one or another part of these kinds of disputes?
Well, yeah, thanks, Martin. And I think, as you say, there are some interesting issues that arise in those types of energy disputes, and in particular, sort of upstream oil and gas disputes, where, as many listening will know, you will have a suite of contracts that are relevant to any block, and the structure will tend to be, and I'll talk about this by reference to Mexico, given that that's one of the reasons why we're here. But you will have a production sharing contract or a license in place between the government and the contracting party, and the contractor here is the party that has been given the rights to explore for and produce hydrocarbons. And in Mexico, interestingly, the production sharing contracts that I've seen contain arbitration agreements, in this case, providing for arbitration under the UNCITRAL rules with the seat in The Hague, but of course, with a contract governed by Mexican law. And that's not always the case with production sharing contracts or licenses. Frequently you will see a requirement that any dispute is resolved through the national courts of the country in question. And the one sort of carve out for that is in the Mexican PSCs that I've seen. There is an exemption to that arbitration agreement that allows issues relating to administrative termination of the contract to be resolved through the Mexican federal courts. So already there we see, under the same agreement, potential different fora for different issues. So underneath the production sharing agreement or the license, there will then be a joint operating agreement between the companies who comprise the contractor under the PSC. And the JOA sets out the details of how those companies will share liabilities, risks, costs, and also the upside, the production and the profits from the hydrocarbon production. And it tends to provide for one of the companies to be appointed as operator and sets out the basis on which that company will carry out the work on the block. Now, typically, JOAs also contain arbitration agreements, and they have a wide variety of forms of arbitration that they provide for. And here, the Mexican JOAs that I've seen provide for ICC or LCIA arbitration, and many are governed by English law. So I guess pausing there, we already see a number of potential fora where any dispute relating to the same block might be determined. And although I think one tends to assume that the PSC and the JOA will lead to different types of disputes, different types of issue, that's not always the case. And you see some issues which really sound in both contracts. And one example of that is issues relating to cost recovery. So cost recovery being the way that the contractor parties are able to apply production to pay for the costs of exploration and production. And that also involves a role for the government in determining what can be used in relation to cost recovery. And here we see, potentially issues arising both under the PSC and under the JOA. And I think kind of one of the criticisms that might be made of arbitration is, well, hold on a minute, you're going to have a dispute with issues that really kind of sound in both contracts, resolved potentially in different fora. And I think for many of those involved in the JOAs, so the international oil companies who are involved in JOAs, their preference would be that any sort of internecine disputes, any disputes amongst them, would not be resolved in front of the government. They want to present a united front to the government and to resolve that issue, the issue that arises under the PSC, in a united way, and then to have their arguments amongst themselves resolved privately elsewhere. And you can see kind of why that might be beneficial. But I guess on the downside, one can also see that for the operator, for example, one might get caught in the middle between a decision under the PSC and then an inconsistent decision under the JOA. So I guess all of those issues that we constantly grapple with in terms of, well, what do you do where you have multiple fora and potentially different tribunals reaching different results can apply. And one has to sort of think about the advantages and disadvantages in each case of that happening.
And I'm not going to jump ahead, but we've also seen the involvement of Pemex as a joint venture partner. But before we go there, I think we will need to hear from others. That is something I think worth talking about, especially in light of what has happened here recently in the last, say, 3 years in Mexico. Mexico was the key word. I think it would be great to hear from Steve Andersen over at the ICDR, the arbitration institution perspective. Steve, you are overseeing the ICDR's operations in the Southwest, including Mexico, even Canada. You have been appointed by the U.S. Department of State to the NAFTA Advisory Committee on Private Commercial Dispute Resolution. It is a pleasure to have you. Please give us the institutional perspective.
Thank you, Martin. It's a pleasure to be with everybody today, and thank you, Rachel, for this opportunity to share some thoughts. Just speaking a little bit generally, as we talk about some of the technology issues and global trends, a few thoughts on that to get us going. We've seen, in specific to technology, a real transition in the use of technology with the ICDR in years past, and even the AAA was what I would say a slightly lower industry user for us. But in the last number of years, it is either the top or in the top 3 in terms of activity and caseloads. So there's been a fantastic and interesting change there for international arbitration. Just as a side note, we've created a working group to do this. And one of the big reasons for this change, I believe, is in the years past, technology was limited to technology companies and their disputes. But now we know that technology is really across all industries. And so that's one of the big reasons for this transition. So this working group is inviting, and even all those here, we have a survey on our website, icdr.org, that gathers information on technology disputes across all industries. Other observations generally, rule changes we had last year that give us some thoughts on that. Cybersecurity is critical, arbitrability is another dynamic, third-party funding, mediation, I'll talk about a little bit more. And I also think the diversity of party and arbitrators and mediators in our world of virtual proceedings has dramatically changed, which is fascinating and fantastic. Let me get into a little bit of Mexico in terms of what we're seeing with that. We are seeing an increase of cases and activity with parties from Mexico, and this includes a variety of industries: energy, construction, technology, governmental entities, entertainment, and others. It's a nice mix of cases, large and medium, and some small where appropriate, right? And over the past few years, in order to accommodate this, we've had to go out and recruit arbitrators and also additional mediators and train them and bring them into the ICDR and make sure they're familiar with kind of the ICDR philosophy on case management and those things that go with it. So that's we're also seeing a number of cases administered wholly in Spanish. I'll talk about Jeanette and her role in that here momentarily. Mediation, we've talked a little about mediation today. I think that's fascinating and important. We have seen a change in mindset, in culture, and in Mexico with international mediation. We've seen cases that were previously they would be adverse or not even attempt to use mediation, and tried it successfully. And this required a rethinking of settlement authority, corporate structure, and all those things that go with it. I think ease of use has also been something that's been very good. We at the ICDR for a number of years have offered what we call a concurrent model of mediation and arbitration, where you start the arbitration and we appoint a mediator and they go concurrently on the timing of what other parties feel. And this has been also a really good success for disputes in Mexico and other locations. I want to mention our rules changed of last year. I think there's a couple points in there that are important to mention. Our new rules now presume when you file an arbitration with the ICDR that the parties will also mediate, which is, again, I think unique in the global market in terms of rules. And so this will really help parties in all areas. There's going to be parties who are still trying to get up to awareness and being comfortable with mediation, but this will help create that conversation. Parties can opt out, but a strong presumption of mediation. It also includes a settlement factor for the Singapore Convention, and we've added to our panels of mediators in Mexico as well. A couple other points I just want to talk about. Jeanette Quiros, I've spent probably almost 2 years of my life cumulatively in Mexico. I think 13 Mexican states, and just love Mexico and the activities we've had there. Jeanette Quiros is our director now in Houston for 7 years, but she spent, I think, about 7 years as the Secretary General at Canaco before that. And so we've worked together for about 14 years now in Mexico and Houston, working with companies and training and recruiting arbitrators and all those things. Her role now is director in our Houston office, handling cases and working with cases from Mexico and otherwise. So it's a fantastic connection and something that has been really helpful, I think, generally, and also for some specific industries, energy, construction, and others. So that's helpful. The other, I guess, just some other ideas on activities. We have lots of activities. We have an advisory committee in Mexico that helps us across the country set up trainings and connections programs. And one of our focuses is, and always has been, is just working with the companies, whether it's one-on-one or offering trainings or programs. And so that's kind of a highlight of what we're seeing in Mexico. Hopefully that gives you a feel. And thank you very much to Martin for the opportunity to share those thoughts with you.
It's always a pleasure to have you, Steve. I should share 2 personal points. One is that I did intern with the ICDR now over 20 years ago. And Steve Andersen was my boss at the time. He was out in San Diego. I was in New York. The early bird special is certainly a crown that goes out west. If you thought I would be working without being able to talk to my then boss, that was impossible. That said, every time you mention rule changes, Steve, my heart beats faster because I have co-authored a commentary on the ICDR rules, which came out in the second edition in the year 2019, and I'm just not sure how many more editions my marriage will take. So please keep those rules steady.
That's one of the goals, Martin. That's one of the goals as we go.
Thank you, thank you. This was an excellent segue to introduce Manuel Vera, our native Mexican partner, who's sitting to my left now. And we will be joined by Manuel Cervantes of MCM Abogados. Manuel Vera has more than 25 years of experience in advising energy companies, financial institutions, and investment firms in acquisitions in Mexico and Latin America. I believe his count is up to more than a dozen countries for these activities to having taken place in. We, of course, here at Bracewell are very involved in energy-related issues, and energy is a broad term that does not only cover oil and gas, but it goes through power, electricity, renewables, and very interestingly, of course, the financing thereof. Manuel Cervantes is joining us virtually from Miami. As Stephen Crain said, he's the managing director of MCM Abogados, one of the Mexican top-tier firms. Certainly in the power sector, the upstream, midstream, and downstream projects. I think I may be right in saying that he and his team currently advise on about 60% of the total oil production operated by private investors in Mexico. Mexico now, of course, is a topic of keen interest to any of us international arbitration practitioners doing investor-state arbitration. NAFTA has been terminated. There is a USMCA, the United States-Mexico-Canada Agreement. I will address that later in the program. President Lopez Obrador, when taking office, had certain intentions. He has made the news on a few projects and issues. Airports primarily are carved out interestingly out of the infrastructure segment of so-called government contracts under the United States-Mexico-Canada Agreement that certainly enjoys some privileges. I'll get to that. I can't wait to hear Manuel, the señores tocayos, to hear about a historic recap in light of, I would say, regulatory aggressive intent. Where did President Lopez Obrador start? What were his intentions? Where have we gotten to as of today? What can be expected? And perhaps even more interestingly, what can be done now to be prepared to safeguard your interests in the future when operating in Mexico? With this, I think we're addressing outsourcing and subcontracting as a ease into the level of governmental aggression. And we'll spend a lot of time on electricity, power, and hydrocarbons and fuels. Señores tocayos, por favor.
Hello, good morning. Can you hear me? So, as Martin mentioned, thank you, Martin. I'm Manuel Vera. So we're going to talk about three different topics. The first one, we generally address the outsourcing and subcontracting matters in Mexico and the changes to the law. Then we will talk about energy reforms or energy environment in Mexico, mainly power, but we will also briefly address the hydrocarbon sector. And finally, we will discuss local measures in Mexico that can be taken and international disputes. And my partners, Martin and John, will also participate in that section of this panel. So let's talk a little bit about outsourcing and subcontracting in Mexico. Why this issue is important. The federal labor law in Mexico provided for many years or long time ago that all the companies needed to share 10% of their annual taxable profits, 10% with their employees. So this was a real burden for the companies if you have taxes, Social Security payments, retirement payments, housing, and other benefits that employees in Mexico are allowed to receive. So the companies started structuring a scheme whereby they form a sister company and affiliate as a services company, and all the employees of that group were hired by the services company. So the operating company or companies in the group, on the company group, the ones that actually have the profits or the sales, they didn't have any employees. So no employees and all the profits there. So there was nothing to pay to the employees. And the services company who entered into a services contract with operating companies had all employees, but very low margin of profit. So the profit sharing was not material. This structure worked fine for many years in Mexico. But during the last years, there was a boom of outsourcing companies. And obviously not all of them, but some of those outsourcing companies start, let's say, abusing the system, not only to avoid the payment of this profit sharing that I described, but also to avoid or to diminish payments of Social Security fees or other benefits that the employer, that a standard employee in Mexico was allowed to receive. So last year, the president of Mexico, Andres Manuel López Obrador, and we will also refer him as AMLO, which are his initials, AMLO, present a very strict or extreme bill in order pretty much to terminate with the subcontracting and outsourcing options in Mexico. It was presented as a bill and it was discussed by the Congress. And now Manuel is going to talk a little bit about what happened with that reform. Manuel.
Thank you, Tocayo, and Martin. Thanks for the invitation to participate with you, gentlemen. As Manuel says, the proposal was very aggressive from the very beginning. One of the main characteristics is to define this subcontracting of personnel as prohibited. And the consequence of doing that with this change is that it would be considered a tax fraud. In addition to that, any expenses incurred paying those bills of the outsourcing companies would not be tax deductible, so pretty much the money would be lost. After several rounds of negotiations, because of the heavy impact this had in the industry in Mexico, in all the sectors, finally it was accepted to allow subcontracting of specialized services to the extent those are not within the main economic activity of contracting company. That means the project companies were required to move all their personnel performing the core activities of the company to the project company itself. And the other requirement was that any specialized service company be registered. Subject to this registration, non-REPSE in Mexico, that is controlled by the Ministry of Labor, and several other requirements, including reporting, having transparency with respect to the contracts that are implemented. And with this change, it was also allowed to have specialized services intercompany. So you can still have some corporate structure where the project company receives support from a specialized service company of the same corporate group, but subject to these limitations. And one of the main changes after the rounds of negotiations was to limit the economic exposure to which the companies would be exposed. Particularly the PTU, the mandatory profit sharing, a cap was established either 3 months of mandatory PTU, or the highest with respect to the PTU that the employees have received in the last 3 years in average. That was probably the main point that allowed to unstuck the problem, and the companies decided to restructure instead of going to judicial challenges in most of the cases.
Yeah, I think something important to mention here is that, and this will be material when we discuss what is going on right now with the negotiations of the amendments to the Constitution related to the power industry or power sector. Again, the bill presented by AMLO, it was very aggressive. And what is important here to consider is that thanks to the opposition, opposing parties, the private sector, even the press, helped to at least to relax the proposed original bill. And again, as Manuel mentioned, a couple of major things that were discussed in the negotiation and actually caused the law to be delayed. It was to put this cap to the profit sharing and also to allow companies within the same group to provide specialized services to the companies within the group. So that will allow the companies not to hire, each company in the group hire general administration, an accountant, etc. So one company can provide the specialized services subject to certain conditions, as Manuel mentioned. So generally, again, I think that most of the companies have, just accept this. Of course, not happy, but again, they have amend bylaws, change structure, move employees, etc. But as long as we are aware, there's not many litigation or arbitration related to the outsourcing. It looks like the companies in Mexico are saying, okay, let's do it.
Let me just put a comment there. We thought it was worth addressing this issue because, of course, power and hydrocarbons have made the news more than I think this issue. John will talk about this issue particularly also having potential to exacerbate private disputes. Maybe I'll ask him to do this now, not in lieu of later. But what I did want to say is this is an area where strategic use of international arbitration is to be thought about. Us investment protection lawyers doing the disputes in the end, we do look at underlying treatises. And we look for robust substantive rights that foreign investors can invoke. The change of the regulatory environment is one of the red flags for those of us doing this, to raise our eyebrows and see what Manuel has described, or the Manuels have described, is irrelevant for analyses such as even in the extreme case, indirect expropriations. They usually come in a creeping form. It could bear on what is called fair and equitable treatment protection, most often expressed as a minimum standard of treatment in Northern American treatises. It does seem as if this particular change of regulations has not triggered activity on that front, but I will come back to these two standards, indirect expropriation and fair and equitable treatment, a little later, because it does bear on what investors can invoke under the new NAFTA, depending on what sector they are in. But perhaps, before we lose track of subcontracting and outsourcing, John, share your experience, how this particular set of changes of rules was of influence in a private dispute.
Yeah. Thanks, Martin. I guess this does provide a very good example of what the two Manuels have been talking about. So we're currently involved in an arbitration arising from a renewable power project in Mexico. And in a way that is often done, the structure is that the owner of the project has contracted with a construction contractor. An EPC contract has been put in place for the plant to be built. And once the plant is built, it then goes into the operation phase. And the same construction contractor is also responsible for the first operation phase under an O&M agreement. And in our case, a dispute has arisen under the EPC contract in relation to delay. So we have an ongoing dispute regarding delay liquidated damages. But before that has been resolved, the parties have moved into the operation phase of the project. And here you have a company conducting operation and maintenance. But because of the effect of the change in law regarding subcontracting and the way that the owner of the project's company had been established and its corporate purpose, and then kind of how the operation and maintenance agreement was expressed, we were left with a problem, which was that we needed to make some changes to the way that the O&M agreement was expressed and how the employees were employed, or for the O&M contractor to register in Mexico. It happened to be a foreign company. And as has been described, in most cases, it would have been possible for that to have been done without too much difficulty. But in circumstances where we have two parties who are engaged in a heavy dispute, which is subject to arbitration, and not interested in really helping each other out, but rather being very concerned about not doing anything which might have an impact on the claims being made in the arbitration, we found ourselves stuck in a bit of a deadlock as to what to do. And it has been an ongoing issue that causes some concern as to how you deal with this in a situation where there isn't easy cooperation between two parties, as you need to try to reflect the changes that are required by the law. So it's an interesting case, and I'm afraid I can't give a tip on how to avoid it exacerbating the dispute, because in fact it has rather caused that.
Well, these are the scenarios that call us to action, I suppose, which we do appreciate, but not our clients. But since this was in the renewables sector, I mean, this is another great segue, I believe, to start talking about power.
Yeah, let's talk about the second topic, and it will be energy, first power and then hydrocarbons. So let me give you a little background, general background. Back in December 2013, the Mexican Constitution was amended in order to allow or increase the private, either Mexican or foreign participation in the energy market, including oil and gas, upstream, midstream, and downstream, and obviously also power sector. As to the power changes or the amendments to the power sector, a new law was issued, the Ley de la Industria Eléctrica, the electricity industry law, which opened to private parties the generation and marketing of electric power, created a new structure and legal framework for the electricity industry in Mexico, based on a multiplicity of generators, a wholesale electricity market, a multiplicity of power marketing companies, and independent system operator named SENACE, or the ISO, who is in charge of the dispatch of the system and administration of the power market. Basically, what this new law provided is that the creation and operation of new government agencies and entities to participate in the Mexican power sector, including the conversion of the CFE. The CFE is the Comisión Federal de Electricidad of the Mexican Electricity Commission, from a public entity into a state-owned, commercially oriented company, and divided the CFE in several, it's called subsidiaries or affiliates, focused in specific sectors, and the spin-off of the SENACE, the one that I mentioned, from the CFE. With respect to power generation and marketing, the new law introduced a wholesale electricity market, where producers and marketers are allowed to sell power. And finally, as to transmission services, the new law provide that while the power transmission and distribution utility services will remain or shall remain exclusively to the Mexican state or the government, well, the state. The Mexican state may enter into contracts with private parties for the financing, installation, management, operation, and expansion of the national transmission grid. And finally, all the permits that were granted before the amendment of the Constitution, which were a lot of permits, what is called autoabastecimiento, autoconsumo in the power sector, or autoconsumption, that they were very popular. And all the contracts entered by private parties before the new law, all were grandfathered by the new law, so continue in full effect. So now, Manuel, why don't you talk a little bit about what is the new proposal or the new amendment to the Constitution and to applicable laws that, most of the people, including us, are panicked. And it's under a lot of discussion right now in Mexico.
Thank you, Tocayo. Yeah, I would refer to main points that are very relevant to the subject matter of our panel, that are pretty much yellow or red flags that we need to carefully follow up, because the scope is a game changer. The scope might be against international treaties and commitments assumed by the Mexican government, and is heavily harming the current situation of the industry. One of the first changes they want is to modify the nature of CFE. Instead of being a productive state company that is organized and structured as other companies precisely to participate and compete with private investors, they want to change it back to a public entity. Doing that, it's a fundamental change. Why? Because in their mind, it's not its purpose to compete. CFE has the same meaning for them as national-energy security. So because of that, there is an intention to protect it, to shield it, and by any means to try to place it in a much better place versus potential private investors, because it's in the interest of the nation. That has been the main idea behind all this reform that is being promoted. The second is to have CFE as the only power supplier of electricity in the country. The third one, and this is where the constitutional change would artificially modify the current situation of the market, is they want to impose a mandate so that at least 54% of all the power that is produced in Mexico is done by CFE. And the participation of the private investment is reduced just to 46%. Here it's important to say that today CFE is generating less than 38% in the market. And the private companies have currently a participation around 62%. They are also proposing to change the rules of dispatch, which means the order in which the power plants are delivered to the system. So instead of being an economic efficient principle, it's going to be just CFE go first. And then let's see, subject to discretion and arbitrary rules that are not clear today. To make this change in the market, it seems that one of the purposes is to eliminate the self-supply structure, the self-supply scheme, and also to try to reduce the participation of independent power producers. To give you some idea, the self-supply scheme currently produces 15% of the country's generation, and the independent power producers around 30%. So that's the way they are trying to recalibrate the participations. eliminate self-supply because you are blaming they are an illegal, fraudulent scheme, which, by the way, has been in place for years, has been sanctioned by banks, participants, investors, taxes, because of course all these companies pay taxes, labor, etc., but now they are blaming that it's illegal. And you probably listen in just this week that there is an allegation by the CRE that Iberdrola, in this self-supply scheme, is doing an illegal business. So that's another point. Other critical point is that they are planning to disappear the regulators, which are the referees of the game. In any regulated market, it's fundamental to have a strong, technically oriented regulators. But instead of doing that, they are trying to strip them out of any power and authority and just have them absorbed by the Ministry of Energy. So by the way, is the one that has sponsored a lot of President AMLO's ideas, no? Clean energy.
And Manuel, those regulators, just for the benefit of the group, are mainly, which are independent, or are the CRE or the Mexican FERC, Comisión Regulatoria de Energía, and the CNH, right? The Comisión Nacional de Hidrocarburos.
That's correct. That's correct. And they are pushing strongly to remove them. They already got control on most of their activity, but they want to kill them for good, no? The other proposal is to eliminate the clean energy certificates, which are financial instruments that were fundamental in the structure of private investors that decided to do business in Mexico based on the existing legal framework. CFE is planning to set the price for any power producer sales, and they are also planning to absorb the ISO that Manuel Vera was explaining, SENACE, which is the operator of the system. So they also want to be the judge and the party and the only one that sells and the only one that can buy your production. And finally, one other point that is critical, they are proposing that any previous permits that have been granted, instead of being grandfathered, as it has been done in the 2013 reform, those just cease to be effective. And this infringes a fundamental principle in Mexico, which is retroactivity, no? They say, because we are introducing that at the constitutional level, there is no breach to the retroactivity principle. But probably here, several things that I have described to you sounds like very relevant red flags in terms of international commitments assumed by Mexico, no? Martin, Tocayo.
Yes. As you consider, really, this amendment is extremely aggressive and will damage terrible the Mexican market.
Let me make one point here.
Sure.
As an investment treaty international arbitration lawyer. These are the fields of classic sunk investments. I think this is the nature. I mean, power generation and then transmission is capital intensive. It requires project financing most often. So if a foreign investor comes in, the out-of-pocket investments have risen by the time this regulatory environment then changes. And where an investor comes from in the treaty context is having trusted in the stability of the regulatory environment when putting usually 1, 2, 3 decades project financing schemes in place. That's just the investment treaty arbitration perspective.
Yeah, that's true. And we will talk in a minute as to what, again, this is just a bill, is under discussion, so it doesn't mean that it's going to pass as it is, as Manuel mentioned, so it's under discussion. But before going to what we think is going to happen during this process, we just want to continue with the bad news and mention The problem that has happened is not only this amendment to the Constitution, is that the activities or the actions that AMLO, the president of Mexico, and his administration has taken against the energy sector, let's talk about power, but since day one, since he entered office 3 years ago. So it's not just changes to the Constitution that will affect, is that the companies have been suffer already the harassment or problems with the position of the government since AMLO took office 3 years ago. So Manuel, why don't you very briefly talk about during these 3 years, some actions that have suffered the company. So this is actually, they're already suffering, right? And there's already maybe litigation or some measures, but there's actually facts that are happening right now. Put aside what is going to happen if the Constitution is amended with this power changes.
Yeah, gladly. You can say that this constitutional reform is pretty much the peak of the iceberg. There are a lot of things that have happened so far. And you may perceive, and that's at least my opinion, that there is a kind of an organized takeover plan that was started from day one. And you can see the progress basically year by year. For example, in the first year of government, the decision was to put on hold everything, to slow down power auctions, to slow down the rounds to assign exploration and extraction contracts. They started to question the permits and the contracts signed by the previous administration. You may recall that one of the first things that the government did was to push and corner companies to renegotiate gas transportation agreements. You may also recall that the head of the main regulators, CRE and CNH, were somehow cornered to resign. People that was leading the technical areas in those regulators with experience that have implemented the 2013 reform with all those years of experience, many of them were removed. The regulators saw that their budget to operate were drastically reduced as well. And one of the things that they did is to issue an official memorandum, which, by the way, is public information, where the president himself enticed the regulators to disobey the existing legal framework if it is not aligned with the principles and concepts that he was pushing. Meetings were organized in that effort. And this can be seen also in the National Development Plan, the 2019-2024 document. You can find there several of these concepts. Then in the second year, they started proposing and implementing substantial changes in regulation. For example, they made changes in the reliability policy. Also, they tried to update the transmission service costs, the porteo, which is a fundamental aspect for the power companies to operate. They tried to change that. So players reacted, started judicial challenges. The courts remained impartial, granted suspensions, and stopped them at the regulatory attempts. In the third year, then they started with the changes in legislation. There was a reform to the electricity industry law in March 2021, and there was a cascade. I don't know if there is other word to describe it, but there was a rain of amparo lawsuits against that reform. We're talking, per official information, that are more than 4,000 amparo lawsuits that were pursued by associations, main players, institutions, COFECE, which is the Mexico antitrust regulator, other political parties. And
just to clarify, Manuel, an amparo is a very useful tool in Mexico. Judicial tool is like an stay. When you go with a court arguing that an action or activity of the government is affecting the rights of the private party. So you go with the court, and the court suspends the actions taken by the government, and they can. While they resolve, they can grant the suspension of the action by the government, and if they resolve in favor, they just cancel the action by the government.
That's right. Interestingly, at the time they faced this, they started with an active harassment through the different authorities involved in the project. You saw surprise visits by the Mexican IRS on tax matters, by the customs authorities trying to block imports and exports that are fundamental. Also, the regulators ceasing to answer applications or modifications to permits unless you are Pemex and CFE. Punishment procedures that they started blaming companies for not complying their commitments, and started with these activities. Today, the environment in Mexico, at least in the power sector, and we will talk later with Manuel Vera about the other hydrocarbons and fuels, but in power sector, the perception is that companies are kind of exhausted because they are facing every single day new challenging actions. And they are living now in the environment of the domestic challenges. And some questions start rising as, okay, but then how can we handle in case this evolves to international litigation means? So that's, I think, a kind of a summary of the last 3 years that have been challenging for the industry.
Yeah, and so really harassment by the government, and so what is going to happen? That's the big question, right? As not as to what's already happening, but as to the reform or the proposed amendment to the Constitution. It's going to pass, it's not going to pass, it's going to pass only maybe a portion of the bill, like what happened with the outsourcing, that based on outside pressure by the opposition, etc., private sector, the press, were achieved. First, just to let you know that in Mexico, in order to amend the Constitution, you need a 2/3 vote of the Congress. First, 2/3 of the House of Representatives, and then 2/3 of the Senate. And then it has to be approved by the majority of the local congresses, the state congresses. And the AMLO party, Morena, the ruling party, together with the two parties that support Morena, which are the PT or Partido del Trabajo, and the environmental party, which is comic because the environmental party is supporting a bill that goes against the environment. They don't have enough votes to amend the Constitution. So they need to get the opposition, some votes from the opposition, convince them to vote in favor and amend the Constitution. The right side party, which is the PAN or PAN, they're not going to vote in favor. The one that is, supposed, they already say that they're not going to vote in favor, but you never know about this party, the PRI. The PRI or PRI was the ruling party for 7 years in Mexico. Then they were out, and then they were again the ruling party in the last administration with Peña Nieto, who actually they are the ones who supported the original reform in favor of the energy market. So again, it's difficult to say. My personal belief is that it's not going to pass as it is. I think that something is going to pass, more flexible. But Manuel, I know that you have your own opinion here, and obviously, again, we don't know. And there's been some pressure, obviously, in addition to this, of the opposition, etc. I'm sure that you already know, or you have seen that the Secretary of Energy of the U.S. visited Mexico and expressed her concerns about the reform. John Kerry was this week also in Mexico and also expressed their concerns mainly from the environmental point of view of the reform. Manuel, what do you think? I know that it's impossible to say what is going to happen, but
yeah, I don't think that it will pass as it is, but I'm concerned that his fundamentals remain even if there are some changes, and if that happens, there's an important risk of legitimacy. His actions may be somehow continue legitimate in front of the people, in front of the nation. And that's very risky because it would, it may diminish the defense and the possibilities of prevail in case of using domestic remedies. So that's basically my concern. And I don't think that it will be just taken out. AMLO will insist and somehow get a reform.
Yeah. I mean, this is a good time to do two reminders. One, we need to talk a moment about hydrocarbons and fuels, almost on an executive summary level. Yeah, but one more point. We're also doing this to give at least some general ideas on what can be done now. And I believe it is important also based on the last 2 decades of Latin American investor-state disputes to always remind foreign investors to think about the evidence that they can rely on in the future and how to secure it today. This starts with record keeping. This continues with maintaining key employees accessible. And this flows into, in extreme situations, to actually bring things out of a country or at least create a second set of such an evidence that is going to be available no matter what that host government is doing. But I don't want to give this grim picture at this point. Perhaps the regulator in Mexico is going to prevent the full-blown disputes.
Yeah, I agree. So we're running out of time. So very briefly about hydrocarbons. The main purpose of this panel was talk about power and the current reform of the Constitution, which is only exclusively to power. The hydrocarbons have not been proposed yet, but we see a mirror that's happening as to the hydrocarbons. Same reform, 2013, opened the market. It was successful. There was, in the upstream, there was several rounds of bids for oil fields, shallow waters and deep waters in the Gulf of Mexico that were really successful. Downstream, for example, if you were in Mexico 10 years ago, you didn't see any gas station other than Pemex. Now, if you go to Mexico, you can see a gas station of Repsol, BP, Shell, you name it. So the downstream also has been open to the market, but also since day one, AMLO has pretty much taken the same position, targeting the private investment, and a mirror of what they're doing with the CFE is with Pemex, that they are just trying to make Pemex the main player in Mexico. Right, Manuel, I don't know if you want to add something about hydrocarbons.
No, quickly, they know the relevance of the fuels sector, so they are eliminating competence. How? They are blocking permits, not renewing them, and retaking control through a closure of terminals, storage terminals. So they are blocking them for import, for export, and at the terminals level. And in hydrocarbons, I would just add that we should not forget that the industry as a whole is subject to a probation period where the president said, okay, I'm watching you. If you don't comply with investment and production, I will start taking measures. And that's the next step they will take at some point.
Yeah, and some analysts actually say that the power reform is a trial or an exercise for AMLO to see how it goes, and then he will go after the hydrocarbons. So let's see.
Well, Pemex was mentioned. John, this is calling you to action. Are you sleeping with a giant when you're in a joint venture with them? Or are you going to raise your voice?
I mean, just two points to highlight. So as we've heard, there is a push to see Pemex kind of have a greater share of kind of what is out there in terms of hydrocarbons. And that's challenging in many ways, because if you have Pemex as a partner in a joint operating agreement, for example, Pemex has some very difficult challenges in front of it in terms of its financing. It has a large debt. It is often unable to fund cash calls, to contribute to the development of fields. So it can be a very difficult partner to have. I think the other point that's kind of interesting to note is that we have seen already a push to kind of give greater opportunities to Pemex, and we've seen an example in relation to the Zama field where there's an issue relating to unitization, where the field goes over 2 blocks, and so there's a question of who becomes the operator. And in this case, the Ministry of Energy has decided that it should be Pemex rather than the operator of the other field, and that's given rise to the threat of an investment treaty arbitration. Talos, the operator of the other field, has indicated that it's given notice that it's considering pursuing a claim under the USMCA or potentially another investment treaty. So I suppose we do see some steps in relation to the hydrocarbons industry that are already having an impact, particularly in the sort of pushing Pemex into the foreground.
I mean, this is a moment to try to bring home a few key points on USMCA as opposed to old NAFTA, and the 5 minutes remaining. NAFTA has terminated in 2020. There are certain legacy investments that can still be made subject to a dispute under the old NAFTA rules. The key date to keep in mind is they have had to be filed by July 2023. There's a 3-year period that addresses pending claims and legacy investments. Certainly something to keep in mind, because for a lot of investments, the Chapter 11 of NAFTA had provided a more robust set of rights that can be invoked in the future. Now, there's a big exception to this rule. There are 5 covered sectors, out of which so-called covered government contracts can arise. So even under the new set of rules, the USMCA, as regards Mexico and the United States, if such a government contract arises out of the following 5 sectors: oil and gas, power generation, telecommunications, transportation and infrastructure, but one needs to emphasize namely road, railway, bridge, or canal concessions, not airports, there is a privileged treatment. The set of rules is wider. It does include what I talked about earlier on, fair and equitable treatment, phrased as minimum standards of treatment. It does include the protection from indirect expropriation. These rights will not be available in the future for American investors in Mexico unless you have a covered government contract qualifying for this set of rules. There's also very different procedural mechanisms in place. If again you are in this privileged group of covered government contracts, I do want to note it says power generation. Power transmission per se is something else, but case law will have to be developed on which sectors qualify, which precise government contracts are in the privileged group. What's important is these privileged groups of contracts do not have a requirement for the exhaustion of local remedies. Such investors do not need to follow through on Mexican court litigation or administrative proceedings in order to qualify. There's a 6-month cooling off period, which is a standard feature in investment treaties. There's also a 3-year limitation of being able to bring the claims that is starting from when the claimant should have acquired or did acquire knowledge of the breach of any material rights protected under the treaties. Now, let me shift over to the non-privileged group for a moment. Again, I mean, if you're not in one of those 5 sectors and have a covered government contract, going forward, your rights are going to be more limited. First of all, you can only claim direct expropriation. The 2 words IN, the 2 letters IN, make a huge difference. The difference between a direct and an indirect expropriation takes a whole different level of governmental aggression on the taking side. Indirect expropriations are often regulatory in nature and creeping. Direct expropriations are active takings. You still may be able to rely in the future on a breach of a national treatment protection, as well as a most favored nation treatment protection. However, most favored nation treatment is a very charged term, and in the future on this prong of the USMCA, a rather narrow set of rights. Those non-privileged investors need to go through consultation and negotiation periods. They do need to give a notice of intent to go to arbitration 90 days before initiation. The reason I'm mentioning this is all of this has to happen within 4 years of having acquired or being deemed to have acquired knowledge of breaches. There's even a 30-month lapse of Mexican court litigation and or administrative proceedings requirement. Now, what that means effectively in light of the 4-year limitation period is that a foreign investor has to make up his or her mind within 18 months on whether to pursue litigation in Mexican courts. So there's urgency. Again, oil and gas is a privileged sector. Power generation is, transportation and infrastructure are. It remains to be seen, what kind of contracts, will be invoked to give rise to this rather limited set of rules. But as Investment Treaty Protection Council, we should not forget to mention alternatives to this. Investments can be restructured. You can invoke more favorable set of treaties. The Dutch, the Spanish jump to mind, providing for robust investor protection. Canadian investors, although they are not subject to Annex 14D, which gives rise to the Mexican-US investor-state arbitrations. So Canada is out of that, but Canadian investors can rely on what's a mouthful. It's the CPTPP, the Comprehensive and Progressive Agreement for Trans-Pacific Partnership. Last but not least, if you're able to lift a dispute to the interest level of a government, there is a chapter in the USMCA that would allow, for instance, the American government to raise a dispute with the Mexican government. That's Chapter 31, under certain requirements. But these are the kind of things that I think foreign investors currently vested in Mexico need to have a keen eye on and closely observe the regulatory environment and trigger the necessary steps at the importantly necessary point of time, or these rights will also go away.
Yeah, I think that it's important, even if a company has not been suffered any action of the government, I think it's important for them to be prepared. Obviously, if they already suffered some type, for example, a permit was denied or revoked, or if the amendment to the Constitution is actually effective, there will be actual damages or actual problems for them. But I think now it's time to start preparing maybe a strategy to how to react in the event of any of these actions.
Yeah. And again, I mean, the topic of today's seminar is strategic use of international arbitration. I can't overemphasize, based on the disputes I have been involved in, investor-state arbitration, and the mere notice of giving to a government that there's an intent to proceed to arbitration, or even a notice of dispute prior to that, it does buy leverage. Because the advantage of a foreign investor then is to be able to deal with your opponent as a whole. If you happen to be in the hands of different agencies of a government, when it comes to investment treaty arbitration, they stand as one. And unfortunately, that's a scenario very common, where you're being handed from one to another, and can't make progress. That's my closing words. John, Manuel, anything to add?
No, I mean, nothing to add to that, Martin. I think those are kind of very important closing words. And as you've encouraged everyone to think about, being prepared. And if there is the potential for a claim, think about the structure of your investment. And once you make your investment, make sure you're thinking about protecting your position all the way through. So no, nothing more than that to add.
Yeah,
Thank you.
on my side, I think I concur with you, gentlemen. It's time to be strategic, be prepared. Take a look at what's going on in power. It may happen to you if you are infused on hydrocarbons. So think also on the side of litigation, international arbitration, and all those tools.
Great. Well, thank you so much. We all will, of course, be available for any questions, especially our virtual audience may have in the future. Maybe we can engage in more Q&A than today. Maybe we'll also have a little bit more time. But again, all of us stand ready to answer any questions via email, phone call, etc. Thank you so much for attending today.
Thank you.